The anti-defection law is a topic that has appeared very frequently in the UPSC question papers. So now, let's try to understand more about that. The anti-defection law in India is a significant legislative measure aimed at curbing the frequent party hopping and defections by elected representatives. Enacted through the 52nd Amendment to the Indian Constitution in 1985, this law, officially known as the 10th Schedule, seeks to maintain the stability of the government and preserve the integrity of the political process. In this comprehensive overview, we will delve into the key aspects of the anti-defection law, examining its historical context, legislative provisions, exceptions, and the impact it has had on Indian politics. Before the introduction of the anti-defection law, the Indian political landscape was marred by a high degree of instability caused by elected representatives frequently switching parties. This practice not only led to political uncertainties but also compromised the trust of voters who elected representatives based on their affiliation with a particular party. The need for a legal framework to address this issue became evident, prompting the government to introduce the anti-defection law in 1985. The anti-defection law defines defection as voluntarily giving up the membership of a political party or voting against the directives of the party. This includes abstaining from voting when a whip has been issued by the party demanding members to vote in a particular manner. The law establishes certain criteria under which elected representatives can be disqualified. This includes switching parties or voting against the party line without obtaining prior permission, as well as not adhering to a party's whip. The disqualification is enforced to deter representatives from betraying the party that nominated them. To prevent the law's misuse and to accommodate certain scenarios, exceptions have been outlined. Members are not disqualified if they form a new political party and at least two-thirds of the members of that party join it. Similarly, in the case of a merger between two political parties, if two-thirds of the members of one party join the other, disqualification is not applicable. One of the distinctive features of the anti-defection law is that the Speaker of the Legislative House plays a pivotal role in deciding on disqualification cases. The Speaker is entrusted with the authority to make determinations regarding defection, including the power to decide whether a member has voluntarily given up the party's membership. Recognizing the potential for biased decisions by the Speaker, the law allows for judicial review of disqualification cases. Members who have been disqualified under the anti-defection law can appeal to the courts seeking relief and challenging the Speaker's decision. The decision on questions as to disqualification on ground of defection are referred to the chairman or Speaker of such house, which is subject to judicial review. However, the law does not provide a time frame within which the presiding officer has to decide a defection case. One of the positive outcomes of the anti-defection law is the reinforcement of party discipline. Elected representatives are less likely to defect knowing that there are legal consequences for such actions. This has contributed to a greater stability within political parties. Despite its merits, the anti-defection law has faced criticism for vesting substantial powers in the Speaker of the Legislative House. The Speaker, being a member of the political party, may face allegations of bias, leading to doubts about the fairness of decisions on disqualification. Over the years, there has been calls for reforms in the anti-defection law to address its shortcomings. Suggestions include reducing the discretionary powers of the Speaker, establishing an independent body to adjudicate disqualification cases, and revisiting the criteria for disqualification to ensure a fair and just application of the law.